clock is now in session.
Please be seated. Good morning. We are here for oral argument in our case number CD 230282, State Farm versus Frank. Each side has 20 minutes for your argument. The appellant may reserve time for rebuttal. I would just ask that you keep that time yourself. There should be a clock on the other side. Our proceedings are being audio and video recorded, so if you can introduce yourself and your client at the start, that would be appreciated. We have read the briefs, discussed the case this morning in conference, and are familiar with the arguments and issues raised. So if you can keep that in mind when making your arguments, we would appreciate it as well. And with that, you may proceed, counsel.
Thank you, Your Honor. May it please the court, my name is Mick Levine. My client is Karen Frank, who's present in the courtroom today. We're here to talk about statute of limitations in a UIM claim. Now, ARS 12555 is the governing statute. That statute indicates that a person shall request arbitration or file suit pursuant to the terms of the insurance contract within 3 years after providing written notice prescribed in subsection A or B of the section. Who's a person? In this particular case, a person is not defined by the statute itself, but there is a general definition of who a person is in the ARSs. ARS 1-21529 defines a person very broadly as a corporation, company, partnership, firm, association, or society, as well as a natural person. In this particular case, that fits State Farm. State Farm requested arbitration of this matter within 3 years after the notice was provided, and State Farm fulfilled the purpose of the statute, which was to request arbitration or file suit pursuant to the terms of the insurance contract. That should be the end of the analysis here. Arbitration was requested by a person, and so the statute of limitations is satisfied. Now, State Farm
sorry to interrupt. There are other contextual clues, though, within 12555C2 that I think could lead one to believe that person is different from the insurer. In fact, the second sentence of C2 uses both person, says if the person does not comply with this paragraph, the insurer is not liable for uninsured motorist coverage benefits or underinsured motorist coverage benefits. The way that sentence is framed makes me think that person is different than the insurer. Why am I wrong about that?
The person, I agree, is probably the claimant because they're referring to the person who's making the claim in that contextual clue, as Your Honor pointed out. A person is not the same as the person. A person is a broader definition of who a person is. The contextual clue in the second sentence, if the person does not comply with this paragraph, the insurer is not liable. It sets out who the person is versus the insurer. But the first sentence, where it says a person shall request arbitration, does not give you that same contextual clue. It doesn't specify a person shall request arbitration or the insurer would not be responsible in that sentence. So while, Your Honor, I understand that the second sentence certainly indicates that the person that they're referring to probably is the claimant, that first sentence doesn't have that same contextual clue. It doesn't set out a differentiation between the person and the insurer, which the second sentence does.
So the legislature has used the term person within the same clause to mean two different things.
As I read the first sentence, Your Honor, a person is not the same as the person. And I realize that this may be splitting hairs, but when we're looking at a person, we're talking about any person. We're not specifying the person who's making the claim. If the legislature intended for that first sentence to apply solely to the claimant, the legislature certainly could have said so. but they didn't.
Well, just...
They made that contextual clue, I'm sorry, Your Honor.
No, go ahead, finish.
They made that contextual clue in the second sentence where they're talking about the claim being barred. They didn't make that contextual clue in the first sentence.
Just
And
conceptually, why would the legislature base operation of the statute of limitation on what the insurance company does versus what the claimant does?
Well, contextually speaking here, Your Honor, if an insurance company is going to request arbitration, then the insurance company has requested arbitration, and an arbitration usually proceeds. So I think the idea here is...
Unless the person decides they don't want arbitration, I think, which is what your client... It looks like the record supports that your client did not participate in the arbitration that was requested by State Farm.
I would say that the record doesn't reflect that my client refused to participate in arbitration. I would simply say that the arbitration was not had. Instead, what happened was a bad faith lawsuit was filed, and that bad faith lawsuit was litigated. Now, that bad faith lawsuit is still pending, and so it's still continuing. The outcome of the bad faith lawsuit really determines whether or not there's going to be any UIM arbitration that needs to be had. If in the bad faith lawsuit what gets determined is that Ms. Frank submitted a demand, the insurance company did not refuse to pay that demand, but instead decided to litigate the issues without saying that they disagreed with what her demand was. And if a jury in that case determines that they did so in bad faith and that an agreement had been reached by acquiescence, then there's no need for a UIM arbitration.
The umbrella policy requires that the insured commence litigation within a particular period of time, right?
I believe that the arbitration, or that the provision regarding UIM indicates that arbitration or litigation must be commenced within that 3-year period.
Well, I think we have two different policies. We have the uninsured motorist policy, and then we have the umbrella policy, right?
Correct.
The way I read those policies, one requires arbitration and the other requires litigation.
I believe as far as the UIM goes for the underlying policy, I believe what it indicates is that on the demand of either the plaintiff or the insurance company, the issues must be arbitrated. But I believe that it also leaves room for, if neither the claimant nor the insurance company request arbitration, then it may be litigated. I do
Let's
agree
assume for a second that the $2 million policy requires litigation.
I do agree with that.
Why is the 2019 bad faith litigation sufficient to meet that requirement?
Because the 2019 bad faith litigation indicated that they had reached a consensus as far as what was owed in this particular case. In that 2019 litigation, we specifically pled that Ms. Frank made a demand for her policy limit, the $2 million umbrella policy, the $100,000 underlying policy, and that State Farm never disputed it. And since they never disputed it, they agreed by acquiescence. That meets the requirements.
What standard should we apply in deciding whether that litigation is sufficient? For purposes of a breach of policy claim, which I think you would agree is different than a bad faith claim. Maybe you wouldn't.
I don't. The policy actually says that litigation has to be commenced. It doesn't say what form that litigation needs to be. It could be a bad faith case. It could be a breach of contract case. It could be a declaratory judgment case declaring that Ms. Frank is owed the money. It can be any type of case as long as litigation is commenced, and litigation was.
And if you went into the 2019 case and you asked the trial court judge there to amend the complaint to add a breach of policy claim, I have to believe that probably would be granted, and then that would relate back to the date of the original filing, right?
I would agree, yes. So to continue, as far as the person who is requesting arbitration goes, I believe that the first sentence, as we discussed, applies to a person, which in this particular context of the first sentence could broadly apply to State Farm just as easily as it could to Karen Frank. And the reason why I say that is because we want to avoid an absurd result by the interpretation of this statute. An absurd result would be that an insurance company could demand arbitration, the insured could go through the arbitration process, the 3 years could go by, and the insurance company can say, well, since the insured never requested arbitration themselves, the statute of limitations has expired, and now we don't have to arbitrate the case, and we don't have to pay anything.
Counsel, do you have any authority for the proposition that the same word in the same section means two different things? Like another case where that's been, where the court has accepted that? I mean, isn't the plain language and the rules of interpretation we're supposed to interpret consistently within the statute? And so I'm asking, do you have a case that you can give us that is applied, that interpreted the same word differently when it's separated by just a couple inches in the books?
I think the way that one comes out, Your Honor, is that I don't have a case that I can specifically reference you to, but I can tell you that a comma matters in defining terms and insurance policies and in statutes.
Right, but we're not dealing with a comma.
I understand.
We're dealing with the same word with the same number of letters and the same...
And I would argue that it's a different phrase. A person and the person are two different things. A person really refers to any person.
Okay, do you have authority for that, interpreting that word in a statute two different ways, a and the?
I think that just comes down to a plain interpretation of the phrase, Your Honor.
Well, to do that, the clear
do.
interpretation is a person is a person is a person.
Right,
What I'm
but
asking you
a
is...
person is different from the person.
Right,
Especially
and that's
in
why I'm asking
context.
for authority. Do you have authority for that proposition?
I don't have authority for the proposition that a person and the person are two different things within a statute separated by two different sentences. No,
Okay,
I just have the plain interpretation of how these phrases can be interpreted.
So
And
then if we begin with talking about a person, and then immediately after we say the person, couldn't we understand that to mean the person we just talked about? That a person, is that what you're saying?
I'm saying that a person generally refers to a person, any person. It doesn't matter what person. It's not a specific enough direction as to who it is specifically that we're talking about.
Right,
When the
but
next,
we...
when the
but
next
we-
sentence says the, it's referring back to
To the same a person.
I don't actually believe so because of the context of the second sentence. And again, the second sentence, it says if the person does not comply with this paragraph, the insurer is not liable.
But doesn't it follow to understand that to mean if the person we just talked about, whoever that person may be, right, the initial person, who could be anyone, if that person does not comply with this paragraph, right? So, because it's talking about the person who's obliged to request arbitration or file suit, right? That's who we're talking about. That's the context.
I don't agree that that's the same context, Your Honor, and this is the reason why I don't agree with that. In that second sentence, it specifically refers to the person and the insurer. It differentiates between the person and the insurer. So the person and the insurer are two different individuals in the second sentence.
Right, so that would have implications for the understanding of a person, which is not...
I don't agree with that, and the reason why I don't agree with that is because in the prior sentence, there's not that clue differentiating a person from an insured. If there was some kind of differentiation, some kind of contextual clue in the first sentence differentiating a person from an insured, I would totally agree with you, but that's not there. What's there is simply that a person shall request arbitration. In the second sentence, it says if the person does not comply with this paragraph, the insurer is not liable.
Well, isn't there a clue because it refers to A or B of this section, and A or B refer to the person making the claims?
A and B do refer to the person making the claims, and it talks about the A and B in this section later on in that same sentence. But that's after providing the written notice prescribed in Section A or Section B of this section, and it doesn't necessarily alter the context for who a person is that's being referred to. And like I said,
You
if the
have other
legislature, I'm sorry?
You want to go into other arguments? You only have 6 minutes left. I'm in this article with the same word.
I have no
I think
problem.
one I'd like to hear a little bit about. Can you talk a little bit about estoppel? In the order on the motion for reconsideration, the trial court said that your client was estopped from arguing that the bad faith case was anything other than a bad faith case. Do you know what form of estoppel she was referring to? And if you do, why was that conclusion error?
I don't know what form of estoppel she was referring to. What I can say is that what happens in the bad faith case is somehow being brought into this case. And I'm not sure exactly how that one occurs. What I can tell you is that in a bad faith case, one of the damages is the policy benefits that aren't paid. And if policy benefits weren't paid in the bad faith case, then it wouldn't make this case, a claim for UIM damages, seem like it had been fulfilled. So I'm not exactly sure what the judge was referring to there. I can tell you that we've pled a form of estoppel in this, and that is that an arbitration was requested. It was requested by State Farm, not by my client, but it was requested in this particular case. And because State Farm requested arbitration, and the arbitration letters were exchanged and what have you, while that arbitration did not progress due to the bad faith case being litigated, it was requested. And so our point in that is simply what I indicated earlier, which is that an arbitration was requested.
Right, but where's the detrimental reliance by your client on that? How did she rely to her detriment on that request?
She relied to her detriment on that request because now they're saying that the statute of limitations prevents her from being able to proceed with an arbitration that they themselves requested.
Right, but I think they would say at the time they made the arbitration request, the statute of limitations had not run.
I believe that that's accurate. At the time that they made the arbitration request, the statute of limitations had not run.
Right, so then time passes and like they would say, well, you can't detrimentally rely on this as this is our position with respect to the statute of limitations when that wasn't even an issue yet.
I believe, I'm not sure that I follow, Your Honor, so let me see if I can explain it in the best way that I can. What my client has is she has a request from State Farm in order to arbitrate this case. She files a bad faith lawsuit. Her allegation in the bad faith lawsuit is that they've agreed to what it was that she demanded, and instead of just going ahead and paying her, they decided to go through this arbitration process in order to try and get something, I don't know, less than what it is that she's demanded. I don't know how, I don't know why.
Let me put it this way. I think you have a good argument on estoppel based on the letter from State Farm saying we will consider the statute of limitations to run from the date of this letter. How does what they said or did with respect to the arbitration get you past that date?
What they said or what they did gets me past that date because we submitted a demand. They asked for arbitration. That arbitration request was made. We assumed that if the bad faith lawsuit that was later filed was not going to result in my client being paid what she had demanded, that the arbitration proceedings would go forward because they requested those arbitration proceedings. So the way that we get past that is that they've already requested arbitration. The arbitration has been requested. Yes, it was by State Farm, not by my client, but it has been requested, and it's assumed that because they requested it, we're going to go through this process. All right, I'd like to reserve what time I have left. Thank you.
Thanks. Counsel.
Good morning, Your Honors. My name is Christopher Robbins on behalf of Plaintiff Appellee State Farm. Your Honors are exactly right. There's no case in the world that says we interpret the same word differently in the same statute, especially in the same subsection. There are only two people involved in the UIM claim. The person who wants to make the claim and make the money, collect the money, and the insurance company. Looking even just at subsection C2, a person shall request arbitration after providing the written notice. The person who provided the written notice was Ms. Frank. She did that, we all agree, on April 20th, 2016. Then, if she does not request arbitration within 3 years after that written notice, the statute says, here is the consequence. The insurance company does not owe underinsured motorist benefits.
And just to push back a little bit, all of the provisions we're talking about use the phrase insurer. So the legislature clearly knows how to use insurer, insured, and it didn't with respect to C2. It says a person, which I hope you would agree is broader than insured or insurer.
Just as it did throughout the statute, Your Honor, it refers to a person. Don't ask me why in an underinsured motorist statute of limitations, uninsured, underinsured motorist statute of limitations, it didn't use the word insured. I don't know why it didn't use the word insured. We often don't know what the legislature does. But they use...
I might be unemployed if we did.
Exactly. There are only two parties mentioned in the entire statute, and they have very distinct and separate roles. The person making the claim, who's, as far as I know, will always be the insured, and the insurance company that will pay the claim. And it makes sense that the obligations would be put upon the person who wants to collect the money, because the insurance company has no incentive whatsoever to request arbitration in the typical situation if they don't know that their insured is actually going to make an underinsured motorist claim. If the person is not going to make an underinsured motorist claim, then there will be no arbitration. It's done. The claim is closed. The file is closed.
Do you agree that the pertinent date, I guess at the earliest that this needed to be filed, an arbitration or litigation, was the 2021 date that was in State Farm's letter saying we will count the statute as running 2 years from the date of this letter?
Yeah, State Farm extended.
You're not fighting that, right?
State Farm extended the statute of limitations far beyond what was required under the statute. The statute itself permits basically a 6-year statute of limitations, because you have 3 years after the accident to file the written notice of your intent, and then you have 3 years after filing that written notice of intent to request arbitration. Not even file arbitration, not do arbitration, just request arbitration. These are the most minimal actions conceivable to permit a party to pursue an underinsured motorist claim, and why they didn't happen in this case, I will never know.
If the policy requires arbitration, but instead the insured runs to court and files a case, why is that not sufficient? I mean, isn't that putting form over substance?
Well, two things. The statute just, as you'll remember, specifically says request arbitration or file suit pursuant to the terms of the insurance policy. The terms of the auto policy are that you request arbitration. That was the method of resolving UIM disputes.
And the terms of the umbrella policy, sorry to interrupt, say litigation, right?
I believe you're right, Your Honor, but you have to resolve it under the underlying policy first before you start looking at an umbrella or excess policy. And the term of, as I said, the term of the auto policy says arbitration. It says request arbitration. If I understand Mr. Levine correctly, this can be arbitrated sometime 20 or 30 or 40 years from now because State Farm requested arbitration. That's not the law. That's not what the statute of limitations was intended to do. The statute of limitations is intended to create finality so that the insured, the person, can get on with their lives, the insurance company can get back to business, close the claim. It serves the same purposes as all statute of limitations. So you have fresh witnesses, fresh evidence. The statute of limitations serves that beneficial purpose that the courts have recognized in lots of cases.
Why was the 2019 bad faith case insufficient to meet the statute of limitations, at least with respect to the umbrella policy?
Because what you're trying to do here, Your Honor, is resolve two issues: liability of the underinsured motorist and the amount of damages. And they did not request that in the bad faith case. In fact, Mr. Levine specifically pointed out to the judge in ruling, the judge was considering State Farm's motion to dismiss that lawsuit, and he specifically pointed out, no, we don't have to resolve the UIM claim. We're talking about the handling of the claim, not the amount of UIM damages. And I think, I'm not sure, you asked the question about the trial court judge's use of the word estoppel. I imagine it's judicial estoppel because they received a benefit in that lawsuit by overcoming the motion to dismiss by claiming that they were not seeking UIM damages or attempting to resolve the UIM claim, and then they come into this lawsuit and say, oh, wait, that we actually did mean to do that. You're not allowed to do that.
Well, my understanding of judicial estoppel is you need to take inconsistent positions on a factual issue. You can't say the light was green in one case and say it was red in another. I don't know that I've ever seen judicial estoppel applied to legal positions in different cases. So that's one question. The other is, for purpose of judicial estoppel, I also understood that the party needs to get affirmative relief based on the factual position. And I'm not sure simply defeating a motion to dismiss qualifies as affirmative relief.
Well, and Your Honor,
your reaction?
We have not briefed this, and I don't think we ever used the word estoppel with the trial court, and I'm not...
Well, the trial court used it.
Yeah, I'm not, and perhaps we should have, briefed that, and I'm more than happy to brief that now. But I will tell you that courts don't like to hear that an advocate has said one thing in one case and then comes to this case involving very, very similar matters and saying just the opposite.
I mean, I guess another issue I have is I'm not sure what he said because it's not really in the record. There's no transcript in the record. I have a 2-year-old minute entry from another judge, I guess, recounting the position that Ms. Frank took. So how is that 2-year-old minute entry, which arguably is hearsay with respect to us, I mean, it recounts what position counsel took, how is that sufficient for your client in terms of getting summary judgment?
I'll say this. First, I'm not, it may be hearsay, Your Honor, and I'm not going to argue about that. But I think you can take judicial notice. And I think this judge certainly recognized that you're coming before me saying that somehow you requested arbitration of a UIM claim by filing a bad faith lawsuit in which you told that judge that you were not attempting to resolve a UIM claim. And I'm not quite sure what the proper legal terminology would be, but that's just wrong. And, you know, we applaud Mr. Levine because he didn't really make that argument. Because it seems to me it would almost be an ethical conflict.
But you agree that if we're going to accept that argument, it's based purely on the minute entry because you didn't provide us with a transcript?
No, we did not provide you with a transcript of the oral argument in the other case.
Putting estoppel aside, what standard do we use to determine whether the 2019 bad faith case is close enough for purposes of meeting the statute of limitations? I mean, I go pull the complaint, I read the allegations. It has to say we are making a claim for benefits under the underinsured motorist policy?
I think yes. And specifically, you can't go back and say, no, we're not making that. What the bad faith claim is dealing with is State Farm's handling of the claim. And so you're going to call State Farm witnesses. You're going to look at the claim file. You're going to, there were attorneys involved in this. You're going to look at the attorneys. You're going to talk about State Farm's handling it. The UIM claim is basically a tort claim. It's Ms. Frank's tort claim against the underinsured motorists. And so you're going to call her medical providers. You're going to look at her medical records. They're two separate and distinct, and I think Judge Adelman pointed that out when he denied the motion to consolidate the two cases. They are separate and distinct actions. We submit again, Your Honor, that the auto policy, which is the one that has to be complied with first, it's the underlying policy, that says that you request arbitration to resolve these two issues. Now, Ms. Frank never needed to actually arbitrate the claim, but if she wanted to recover UIM benefits, then she either had to accept State Farm's offer of settlement or arbitrate. That's the way that if she accepted State Farm's argument, they have an agreement, it's done, it's over. If you have a dispute about those issues, then the policy's method of resolving it is by arbitration. And the statute recognizes that each insurance company may have a different way of resolving that issue. Sometimes it's arbitration, sometimes it's a lawsuit. And what the legislature said is, therefore, you have to do it in accordance with the insurance policy, with your own insurance policy. There was no settlement agreement here, Your Honor. Your Honors. A settlement agreement requires an affirmative offer, an affirmative response, affirmative acceptance, offer and acceptance. That never happened. They claim, in fact, in the bad faith lawsuit that their bad faith claim is because State Farm took no action.
Yes, if Ms. Frank went into the bad faith litigation and moved for leave to amend to add a UIM claim, don't you think that would be granted?
No, because she's still suing under the auto policy, and the auto policy says the method of resolving that dispute is by arbitration.
Well, with respect to the umbrella policy, what do you think would happen?
I think it would have to be denied because I think you don't get to the umbrella policy until you do the underlying policy. And here's a curious thing. State Farm was willing to do the arbitration. If they had accepted and gone forward with the arbitration, this would all be done. It would all be over. We wouldn't be here in front of you. But they never have. They never have. And the accident was in 2015, and they have never expressed any willingness to arbitrate the case.
So if we say, if we affirm with respect to the statute of limitations on the auto policy, you're saying that's the end of matters because you don't get to the umbrella policy then?
Yes, Your Honor. They talked about equitable estoppel and equitable tolling. there is nothing State Farm did or could do to engage in any affirmative contact that would have prevented her from requesting arbitration. Equitable estoppel simply doesn't apply here. Equitable tolling requires some showing of an infirmity, a recognized disability or infirmity on the side of the party seeking equitable tolling, and there's no showing of that whatsoever. In fact, Ms. Frank was represented by very competent and well-respected attorneys throughout this matter. And the curious thing is, by even talking about those doctrines, she concedes that she did not comply with the statute of limitations statute. She did not comply with 12-555. She is asking the courts to give her a break by saying that. And then let me add one other thing. They admit that State Farm denied the claim on December 7, 2020. They still had 5 more months to request arbitration. And all it required was a letter to State Farm saying, we request arbitration, let's go. 5 months. So that's not a reasonable time to delay when you never request arbitration. And they've made it clear that they never will and they never would. We think the analysis is just as simple on our side as Mr. Levine thinks it is on their side. She complied with the 2 things required under subsection B, which is must give written notice to insurer of her intent to make an UIM claim within 3 years after the day of the accident. She did that. Everybody agrees. She did that. She must make a tort claim against the tortfeasor's insurer within the 2-year statute of limitations for torts. Everybody agrees that she did that. She settled with the tortfeasor for that tortfeasor's liability limits. Subsection C2 says, here's the last simple thing you need to do. If you want UIM benefits, you need to request arbitration according to the terms of the policy. And then it says in clear and unambiguous language, if you don't do that, the insurance company, in this case State Farm, is not liable for underinsured motorist benefits.
I know it's not really an issue in this case because State Farm unilaterally extended the claim deadline, but do you think under the statute the insurer's failure to provide the notice it is required to provide has an impact as a matter of law on the period that the insured has to then file the claim?
No, Your Honor. I think I'm trying to decide why they added C1, because it says the insurer shall provide a written notice, which State Farm did, by the way.
Late.
1 month late. 1 month late. But then you go on to C2, and it doesn't reference that at all. There's no reference at all. I think what the legislature was doing is we're going to say, insurance companies, please give your insureds one more chance, one more opportunity by putting this down in writing. But then the C2...
And you have to do it a year in advance of the 3-year period running because the insurance company has to do it within two years, right? So that would still give a year for the insurer to file the claim after getting the insurance company's notice.
Right. And remember, it's just a letter requesting arbitration. That's all the statute requires, nothing more. It's a letter from the insured or from the insured's attorney saying, okay, we request arbitration, let's go. They never did that. Never. Not to this day. They haven't done that. Thank you, Your Honors.
Thank you. Rebuttal.
quickly, because I only have 2 minutes. I want to address the underlying policy that you asked about in that arbitration versus litigation. The specific policy says if there's a disagreement, then the disagreement will be resolved by arbitration upon written request of the insured or State Farm. If the insured doesn't make a written request, if State Farm doesn't make a written request, then what? It gets litigated.
That's the auto policy?
That's the auto policy. Then what? It gets litigated. And the reason why I say that is because I understand Your Honor's position as far as the underlying policy has an arbitration requirement, but that requirement is conditional upon either State Farm or the insured making a request for arbitration. If neither makes a request, I don't believe that it is off limits for the insured to go to court, file litigation, and request a ruling as far as how much her UIM arbitration case is worth. If State Farm then makes a request for arbitration, or the insured then makes a request for arbitration, I believe that perhaps that case might be dismissible based upon the request for arbitration.
Unless you show up and say this isn't about the policy, it's about bad faith. So the arbitration provision doesn't apply.
I believe that the arbitration provision still applies as long as litigation is filed regarding the UIM claim. And what that bad faith litigation...
Well, regarding the UIA claim, in what form?
In order to be paid under the UIM policy, which is what that bad faith litigation specifically says. I understand that he says that it's about the claims handling of the UIM claim, but that's not the only part. There's one more part to that bad faith litigation, and that's that there was some agreement between my client and the insurance company regarding the value of her claim, because State Farm never disputed her demand for the policy limits. Now, if there's an agreement between these parties as to how much that claim is worth, we never get to arbitration. And that's what that bad faith litigation asserts, is that there's an agreement between the parties as to how much that litigation...
Is there also an agreement between the parties to litigate since your client never responded to the request?
I'm sorry, I'm not sure that I understand.
If we are to understand State Farm's silence as acquiescence, then can we do the same with your client's silence as to their request to arbitrate?
I agree.
So she's in agreement to arbitrate? That's how State Farm should have interpreted that?
I believe that when State Farm sent a request for my client to arbitrate, and my client did not say an outright refusal, no, I'm not going to do that, then yes, I agree. That's an agreement to arbitrate if they don't already have an agreement based upon State Farm's acquiescence.
One last question. I asked whether, if we find as a matter of law that the claim was laid on the auto policy or barred, what impact does that have on the claim under the umbrella policy? Council takes the position, then we're done with the umbrella policy too. Do you agree with that?
I disagree, and it's kind of a curiosity here. If the underlying policy requires arbitration, which I don't concede that it does based upon the language, but if it did, the umbrella policy indicates that it requires litigation, and so litigation was filed here, and I agree with Your Honor's contention that a Rule 15 motion could be successfully had in the bad faith case in order to address that issue.
Okay, thank you, counsel. Thank you both for your helpful arguments. We will take it under advisement, have a decision in due course, and we're going to recess now so counsel for the next argument can get ready.
Thank you.